bothered by a smell in your condo that just won't go away? Maybe it's drifting from another unit and you think, ugh, first world problems.
Right. Happens all the time.
But what if that persistent odor snowballed into a major legal showdown, like a case that actually set important precedents for condo owners and their associations everywhere?
Yeah, it's fascinating when those individual annoyances run headfirst into the complex world of community living rules and, responsibilities.
Oakley.
And that's exactly what we're unpacking in this deep dive.
So today, we're plunging into the legal battle of Ritter and Ritter, Inc., Pension and Profit Plan v. the Churchill Condominium Association. Whew, that's a mouthful.
It is.
Now, we've got some serious source material for this one. The actual court briefings, the appellate court opinion itself. So it's the real legal nitty-gritty.
Exactly. It's a deep well of information, sure. But it's essential for grasping the intricacies of how these condo communities are governed and the legal lines that get drawn.
Right. So our mission today is to dissect this case. We want to get a crystal clear understanding of what condo associations are truly responsible for, and importantly, where the liability of individual board members ends.
Yeah, that's key.
This case is a prime example, and by the end, you'll have a much sharper sense of your rights, the association's duties, whether you're currently living in a condo or maybe thinking about buying one.
Good stuff to know.
Okay, let's get into it. Where did this whole smell saga even begin?
Okay, so our story starts at the Churchill. It's a 110-unit condo building located in the Wilshire corridor of Los Angeles.
Okay.
Originally built as apartments way back in 1960, converted into condos in 1976. So it's a building with some history.
Definitely.
And importantly, it has its governing documents. The CC&Rs, that stands for Covenants, Conditions, and Restrictions, and its house rules. These are basically the rule book, right, for how the whole community operates.
Right, the fine print of condo life. Got it. And the building had a specific way it was constructed, involved concrete slabs and something called a plenum area. That sounds kind of technical. What exactly is that?
Think of it like this. You've got the concrete floor of your condo unit.
Okay.
Now, before you get to the ceiling of the unit below you, there's often this hidden space that's the plenum.
Ah, okay, like a gap.
Yeah, like a cavity. It's where all the essential building systems run things like pipes, electrical wires, ventilation ducts. Now, during the original construction, holes were made in those concrete floors. These are the slab penetrations to allow these utilities to, travel vertically between the different units.
Okay, so holes for all the building's guts. Makes sense. But the problem was these holes were supposed to be fireproofed, right? That was in the original plans.
Precisely. The initial architectural blueprints the city permits, they require these slab penetrations to be properly fireproofed, to prevent the spread of fire between floors.
Crucial in a multi-unit building.
Absolutely. However, for reasons that aren't entirely spelled out in the docs we have, this fireproofing work, it was never actually completed.
Really? Never done?
Never done. Despite this pretty significant oversight, the Churchill passed its building inspections, got its certificate of occupancy back in 1962.
Wow.
So these unfireproofed penetrations were considered an existing non-conforming condition under the local building codes.
Meaning
they didn't meet the current code standards, but because the building was approved as it was originally built, they were essentially grandfathered in.
Ah, okay. So legal, but maybe not ideal by later standards.
Exactly. Even though they weren't up to the latest regulations, they were technically legal because of that original approval.
So flash forward to the Ritters. They purchased 2 adjacent units, 3H and 3J, in 95 and 98. And it wasn't long after that the smell saga began.
Exactly. They started noticing smoke odors just wafting into their units. Initially, when they raised these concerns with the building management, well, their complaints were pretty much dismissed.
Oh, typical. It's probably just you.
Kind of. The manager suggested the problem was with their own air conditioning unit. So the Ritters actually went ahead and replaced their AC.
Oh, wow. Okay.
But the smell persisted. Then management told them, well, no other homeowners are reporting similar issues.
Always frustrating. Makes you feel like you're crazy.
Totally. Like you're the only one experiencing this problem in the whole community.
Absolutely. So what was the turning point? What finally got the ball rolling on this?
The real turning point came in 2003. A tenant living in the Ritters Unit 3J specifically complained about cigarette odors.
Confirmation from someone else.
Right. And this complaint really pushed the Ritters to demand that the Churchill take the issue seriously, investigate the source of these persistent smells, and do something about it. They insisted on action.
And that led to some investigating, some actual digging into potential sources.
Yes. The Ritters decided to take matters into their own hands, basically. They hired their own independent engineer.
Smart move.
And this engineer's investigation concluded that the slab penetrations we talked about earlier, they were, in fact, the source of the odor problem.
Okay, so proof.
And even more alarmingly, the engineer also identified these unfilled holes as a significant fire hazard, like creating a pathway for fire to spread rapidly between units.
Whoa. Okay, that's much more serious than just a smell.
Much more serious. Subsequently, the board of the Churchill also hired their own team of experts.
Okay, standard procedure.
Now, while these experts might not have fully agreed with the Ritters engineer on the, let's say, extent of the odor issue in Unit 3H, they did concur that the slab penetrations in Unit 3J were contributing to the smell problem.
So they agreed on 3J at least.
Yes. And crucially, they also acknowledged that these penetrations presented a fire safety risk.
Ah, okay. So both sides experts are now saying, yes, holes exist, smell can travel, and importantly, fire could spread.
You got it. Agreement on the core issues. Odor transfer and potential fire spread because of these holes.
Okay, so everyone agreed these holes were there and could cause problems. The logical next step would seem to be, fix them throughout the entire building. Address the root cause.
Well, here's where it gets really interesting. The board, after their investigation, arrived at a, let's say, different conclusion, specifically about who should bear the responsibility for fixing these things.
Okay.
They argued that the Ritters' 1999 remodel of Unit 3J had somehow triggered a requirement under the updated 1999 building code to fill any exposed floor penetrations.
Wait, what? How does a remodel trigger fixing something that was already there?
Their reasoning was that the renovation work had somehow uncovered or disturbed these pre-existing penetrations,
Okay.
thereby making the Ritters responsible for fixing them. Not just in their own units, 3H and 3J, but potentially even in the unit directly below them, 2J.
That sounds a bit like shifting the blame, doesn't it? Like saying, you stirred things up with your renovation, so now you're on the hook for fixing a pre-existing building-wide issue.
It definitely had that flavor. And the board was quite firm in its stance. They would not undertake a building-wide repair project.
Why not?
They maintained that because these penetrations were existing non-conforming conditions, remember, grandfathered in from the original construction,
Right.
the Churchill had no legal obligation to fix them throughout the entire building, and therefore wouldn't incur what would likely be, substantial expense for such a widespread repair.
So instead of a comprehensive fix, what action did the board actually take?
They really doubled down on their position about the Ritters' responsibility. They held a formal hearing in 2004. The Ritters presented their case.
Mm-hmm.
And the board stood by their initial assessment. They issued an order requiring the Ritters to fill the slab penetrations adjacent to their own units, 3H and 3J, within 30 days.
Okay, you fix your part.
And to further incentivize compliance, or perhaps as a form of pressure, they imposed a significant penalty, a $200 per day fine. For each day, the repairs remained incomplete after that 30-day window, although they did say the fines would be waived if the work was done within that initial period.
A $200 daily fine? That's a pretty aggressive move. And the Ritters, I'm guessing, refused to comply under those conditions.
They did indeed refuse. They continued to dispute the board's assignment of responsibility, weren't willing to undertake the repairs on those terms.
Can't blame him.
So this fundamental disagreement, the escalating penalties, it led directly to the lawsuit.
Oh.
The Ritters filed in May 2004, naming the Churchill and its individual directors as defendants.
Okay, bringing everyone in.
And not to be outdone, the Churchill then filed a counter lawsuit, legally known as a cross-complaint against the Ritters,
Of course they did.
seeking a court order to compel them to fill the penetrations and to recover the considerable sum of $77,000 in accrued fines by the time the case finally made it to trial.
$77,000 in fines.
Yeah.
Wow. Relations must have been pretty frosty by then.
Oh, absolutely. Quite adversarial, as you can imagine.
So this went to trial. And it sounds like the case had different parts decided by different people. Jury for some, judge for others. Can you explain that split?
Certainly. So in legal proceedings, certain types of claims typically go to a jury, others go to a judge.
Right.
In this case, the Ritters' legal claims, things like their allegations that the Churchill had breached the CC&Rs, basically broken the community's rules, had acted negligently, meaning failed to act with reasonable care, causing harm, and had breached their fiduciary duty, failed to act in the best interests of all homeowners.
Okay, those are the core complaints.
Right. These were all presented to a jury for a decision. The other aspects, often called equitable claims, likely involving the Ritter's request for an order requiring the Churchill to take specific actions, that's an injunction,
Got it.
and the Churchill's request to compel the Ritters to make the repairs, these were decided by the judge alone in what's called a bench trial, no jury.
Okay, so the jury looked at whether the association broke the rules or acted wrongly. Judge decided on the specific actions and remedies. And what did the jury conclude? What was their verdict on those legal claims?
The jury actually sided with the Ritters on all three of those legal claims against the Churchill itself.
All three. Wow.
Yeah. They found the Churchill had breached the CC&Rs, had been negligent, and had breached its fiduciary duty to the Ritters, and that these actions caused them harm.
Okay.
They even specified exactly which parts of the CC&Rs were violated. Sections 5.1335 and 5.16. Now, the specific language isn't detailed in our sources, but it likely related to the association's duty to maintain common elements, ensure safety, quiet enjoyment, that sort of thing.
Makes sense. Did they award damages?
They did. The jury awarded the Ritters $4,620 to cover their economic losses. However, and this is interesting, they also found the Ritters themselves bore some responsibility for their harm.
Oh, how much?
They assigned 25% of the responsibility to the Ritters, the remaining 75% to the Churchill.
Okay, so shared fault, but mostly the associations.
Exactly. And crucially, the jury found no individual liability for any of the named directors. They weren't held personally responsible.
That's a big point.
Huge. And regarding the Churchill's cross-complaint demanding those fines, the jury also sided with the Ritters, awarding $0 in fines to the association.
So, a clear win for the Ritters against the association as an entity, even if they shared a bit of blame, and the directors walked away personally clean.
That's a great summary. And it highlights that key legal distinction between the association as an organization and its individual board members.
So the association was on the hook for damages, but the individual board members weren't personally liable. That's a really important distinction to note. And what did the trial court judge then decide in the official judgment based on the jury's findings and those equitable claims?
The trial court's judgment, issued in October 2005, largely followed the jury's lead, but also addressed the equitable issues, the what needs to be done parts. The judge ordered the Churchill to take action, specifically mandated that the association fire stop and seal all the slab penetrations adjacent to the Ritters units, 3H and 3J.
Okay, so fix the Ritters' immediate problem area.
Exactly. And this work had to be done at the Churchill's sole expense within 60 days, with a specific requirement for a 2-hour fire resistance rating for the materials used.
Pretty specific instructions.
Very. The judge also ordered the board to hold a special meeting for all homeowners, with experts present, to fully explain the whole issue, the slab penetrations, the potential fire hazard, the association's responsibilities under the CC&Rs. Full disclosure.
Forced transparency, basically.
Pretty much. However, the court did not grant the Ritters' broader request for an injunction that would have required the Churchill to undertake repairs throughout the entire building.
Ah, okay. So a partial victory for the Ritters. They got their area fixed, forced the association to educate everyone, but no building-wide fix ordered by the court.
Precisely. A mix of outcomes at that trial level.
And there were some follow-up actions after the trial concluded, right? What happened next?
Yes. The trial court issued a clarification, just making it crystal clear that the Churchill was indeed responsible for paying for the repairs next to the Ritters units.
Dotting the I's.
Right. The board complied with the injunction. They had the necessary work done. They held the mandated homeowner meeting.
Okay.
However, at that homeowner meeting, when the issue of a potential building-wide repair assessment came up, basically, a special charge to all owners to fund the bigger project.
Vote?
Yeah, the vote. It was overwhelmingly rejected by the other homeowners.
Oh, really? By how much?
The vote was 78 against the building-wide repair and only 3 in favor.
Wow. So despite their legal victory for their units, the Ritters' hopes for a comprehensive fix for the whole building were effectively dashed by their neighbors.
Exactly. That really paints a picture of the community dynamics, doesn't it?
It really does. But the Churchill wasn't ready to accept the trial court's decision, were they? They decided to appeal. What were their main arguments when they took the case upstairs?
They raised several legal points on appeal. One key argument was that the jury's verdict, finding the Churchill liable while finding no liability for the individual directors, was inconsistent, couldn't stand legally.
Okay, try that angle again.
Right. They also argued that the CC&Rs should be the sole determinant of rights and obligations here. Basically, if it's not in the CC&Rs, we don't have to do it. A big part of their appeal focused on the Lamden Rule. This is a legal principle about judicial deference to condo board decisions. They claim the trial court messed up applying this rule.
We'll need to unpack that Lamden Rule.
Definitely. They also challenged the specific jury instructions given at trial, the judge's order for the injunction forcing the repairs, and the court's decision that the Ritters were the prevailing parties, which matters a lot for who pays legal fees.
Yeah, attorney fees can be huge. So a fairly comprehensive appeal hitting several key points.
Yes, covering a lot of ground.
Okay, let's get into what the appellate court actually decided. This is where we really see the key legal principles clarified. Let's start with this idea of separate liability association versus directors. What did the appeal court say?
This was crucial. The appellate court firmly upheld the trial court's position. They stated that the legal liability of the condo association as a corporate entity is separate and distinct from the personal liability of its individual directors.
So they can be treated differently in court?
Absolutely. They emphasized it's entirely possible, under law, for the association to be found liable even if the individual board members aren't personally responsible.
How did they reason that?
They reasoned the jury could have concluded that the Churchill, acting through its agents, employees, or just the overall condition of the common areas, had breached its duties, without necessarily finding that the specific named directors had individually acted in a way that met the legal threshold for personal liability.
So the organization failed, even if you couldn't pin blame on specific volunteer directors for that failure.
Exactly. The association as a whole can be responsible even if the individuals on the board are not personally at fault.
That makes a lot of sense. The association is its own legal entity. Okay, what about the Churchill's argument that the CC&Rs should be the only thing that dictates their responsibilities?
The appellate court acknowledged, yeah, the CC&Rs are foundational, they carry significant legal weight.
Of course.
However, they made it very clear that condo associations also have responsibilities and duties that arise from what's known as common law.
Common law, meaning?
It's the body of legal principles built up over time through court decisions, not just written statutes or contracts like CC&Rs. Specifically, they reiterated that property owners, including condo associations for common areas, have a common law duty to maintain their property in a reasonably safe condition to prevent harm.
Basic landlord-type responsibility applied to the association.
Kind of, yeah. Furthermore, the court pointed out that associations can also be held liable for violating statutory laws or local building codes, even if those laws aren't explicitly mentioned in their CC&Rs.
So, CC&Rs are important, but not the whole story. There are broader legal duties.
Exactly. They're a critical piece, but not the only source of legal obligations.
And then there's the Lamden Rule. We touched on this, courts deferring to board decisions. Can you explain a bit more? What is Lamden and how did the appellate court view it here?
Certainly. The Lamden Rule comes from a big California Supreme Court case. It's often called the Judicial Deference Rule for HOAs.
Okay.
Essentially, it says courts should generally defer to the decisions made by a condo board about maintaining and repairing common areas, provided those decisions are made in good faith after reasonable investigation and are consistent with the governing documents and laws.
So judges shouldn't second-guess reasonable board decisions.
Right. The idea is courts aren't property management experts, so they should respect the business judgment of the elected board. They're not supposed to micromanage every decision about, say, landscaping or paint colors, as long as the board acts reasonably.
Makes sense. Keep the courts out of the weeds of running the building.
Precisely. And the appellate court in Ritter actually quoted Lamden to clarify this. When a duly constituted community association board, upon reasonable investigation and with regard for the best interests of the community association and its members, exercises discretion within the scope of its authority, to select among means for discharging an obligation to maintain and repair, courts should defer to the board's authority and presumed expertise.
So it applies when the board is choosing how to meet an obligation.
That's the key context emphasized.
But the appellate court here concluded that Lamden didn't necessarily protect the Churchill in this situation, right?
That's a really critical point from this appeal. The court emphasized that while Lamden might indeed offer protection from personal liability for individual directors of a nonprofit HOA making good faith decisions,
Okay.
it doesn't automatically shield the association entity itself from liability in all circumstances.
Ah, that distinction again.
Yes. They stated explicitly that Lamden doesn't provide blanket immunity to the association, especially when there are underlying breaches of duty, violations of governing docs or laws, or when inaction leads to harm or creates safety hazards, like, a fire risk.
So it protects the volunteers making judgment calls, but not the association itself if it fundamentally drops the ball on safety or its duties.
You nailed it. They actually said the rule of judicial deference provides protection from personal liability for the individual directors. It does not follow and is not true that the same rule will also automatically provide cover to the entity itself.
So Lamden is a shield for the directors, maybe, but not necessarily armor for the whole association if it fails its basic responsibilities.
Exactly. Especially regarding safety. That's the crucial takeaway on Lamden here. It offers some protection for directors' good faith decisions, but it doesn't let the association off the hook for its fundamental duties.
That's a really important distinction for condo owners. So Lamden wasn't going to excuse the Churchills' inaction on these dangerous slab penetrations. What about the trial court's order forcing the Churchill to actually make the repairs in the Ritter's units? Did the appellate court uphold that injunction?
Yes, they did. They affirmed the trial court's decision to issue the injunction, said it was justified, supported by substantial evidence from the trial.
What evidence did they point to?
Several key things in the record. The fact that the unfireproofed holes were a deviation from the original approved building plans, that they didn't comply with current building codes, and most significantly, that they constituted a clear fire hazard. Especially, they noted, in a high-rise residential building like the Churchill.
The high-rise aspect probably weighed heavily.
Very likely. The court specifically referenced the trial record, saying this evidence, quote, provided substantial evidence for the trial court to consider and injunctive relief was appropriate. They also noted including the directors in the injunction order was proper because the association, as a corporation, acts through its board.
So the fire hazard was key. They had to fix it where the Ritters were affected. Okay, finally, let's talk prevailing party. Who ultimately won, legally speaking? Because that determines who pays the lawyers, right?
Absolutely. And legal bills in these cases can be astronomical. The appellate court agreed with the trial court. The Ritters were the prevailing parties for awarding attorney fees and costs.
How did they figure that out?
They cited a specific California law, Civil Code Section 1354C, saying the prevailing party in an action to enforce HOA governing documents gets reasonable attorney's fees. To decide who prevails, the court looks at the overall outcome, compares what the party achieved with what they originally asked for, what their main goals were ensuing.
So it's not just about winning every single point. It's about achieving your main objective.
Exactly. Substance over form. Did you get the main things you went to court for?
And even though the Ritters didn't get the building-wide repairs they wanted, they were still considered the winners.
Yes, because they achieved several significant, substantial objectives. One, they got a legal finding that the Churchill had breached its CC&Rs and acted negligently, causing them harm.
Okay, vindication on the core issue.
Two, they successfully defended against the Churchill's cross-complaint. They didn't have to pay that $77,000 in fines the board tried to impose. That's huge.
It avoids a massive bill.
Three, they got a court order forcing the Churchill to fix the dangerous penetrations next to their units at the association's expense.
Got the immediate problem solved.
And four, their lawsuit forced the Churchill to hold that special meeting, inform everyone about the fire safety issue, and hold that vote, even though the vote failed. They forced disclosure and action.
So they achieved quite a bit, even without the full building fix.
Right. The court referenced another case, Su via Barra, saying courts should compare the relief awarded with the parties' demands and their litigation objectives, and should respect substance rather than form, and be guided by equitable considerations. They specifically highlighted the Ritters avoiding over $80,000 in potential fines, too. So, yeah, despite not getting everything, they won enough significant victories to be deemed the prevailing party.
It sounds like a really complex calculation, figuring out who really wins in these long legal fights. Now, we know there was a concurring and dissenting opinion from one justice, Justice Rubin. What was his different take?
Justice Rubin agreed with the majority on the main points he concurred, that the Churchill was liable for breach of duty, and he agreed with upholding the injunction ordering the repairs next to the Ritters' units.
Okay, so agreed on liability and the specific fix.
Yes, but he dissented specifically on the attorney fees issue.
Why?
He argued that the individual directors, who were found not liable on any cause of action against them,
Right, they were cleared personally.
They should have been considered prevailing parties in their own right, and therefore should have been awarded their own attorney fees. He pointed to California law, protecting volunteer directors of nonprofits, aiming to encourage people to serve on boards.
Interesting point. If they're sued personally and win, shouldn't they recover costs?
That was his argument. He also felt the Ritter's success was limited. They failed to get the building-wide repair order. So he suggested the trial court might have abused its discretion in finding that the prevailing parties on their entire complaint, or at least that the amount of fees awarded to them was maybe unreasonably high given they didn't achieve their biggest goal.
So he thought the directors deserved fees, and maybe the Ritters got awarded too much given their partial success.
Essentially, yes. His dissent really focused on the fairness and proportionality of the attorney fee awards in this complex situation.
That really gives us a full picture of this quite dramatic condo dispute, from an annoying smell all the way through appeals court arguments about fees. So for you, the listener, wrapping this up, what are the key takeaways from this whole Ritter v. Churchill saga? What should people really keep in mind?
Okay, several crucial points stand out. First, condo associations have a fundamental responsibility to maintain common areas safely. It's not just about looks or convenience. It's about safety and well-being. This comes from both legal precedent, common law, and their own rules.
Duty of care is real.
Absolutely. Second, while the business judgment rule, the Lamden Rule, offers some protection to individual board members from personal liability for good faith decisions.
Right, protects the volunteers.
The association itself, the entity, can still be held legally responsible if it breaches its duties, violates rules or laws, or lets unsafe conditions persist. That distinction is vital.
Entity versus individual directors.
Got it. Third, when disputes happen, courts look at the big picture, who achieve their main goals to determine the prevailing party for attorney fees. It's not always clear-cut, and it has major financial implications.
Prevailing party analysis is key.
And finally, this case clearly shows that even long-standing, existing non-conforming conditions, things grandfathered in, can still lead to legal liability for the association if they're later found to pose a significant risk or cause harm. It was always like that isn't necessarily a defense if it's dangerous.
So what started as a seemingly minor nuisance, a lingering smoke odor, really opened up a huge can of worms. Legal liability, safety hazards, community votes, massive potential costs.
Exactly. Significant legal and financial ramifications for everyone involved.
It highlights that condo living, while offering convenience and shared amenities, really comes with this complex web of shared responsibilities and potential legal complexities that go way beyond just paying your monthly dues. So, considering this case, what questions does it raise for you, our listener? About your own condo association, maybe? Or a property you might be considering buying? Does it perhaps change how you might approach concerns about common area maintenance or safety issues in your building? It certainly provides some valuable food for thought.
Absolutely. This case really reinforces the importance of, taking the time to understand your condo's governing documents, being informed about your rights as an owner and the corresponding duties of the association.
Know your CC&Rs, basically.
Yeah, and maybe even prompting you to delve a little deeper into the specific language of your community's rules, local regulations, just understanding the framework you're operating in.
Definitely. And that's precisely what we aim to do here on the Deep Dive, give you that shortcut to understanding complex information so you can be well-informed, maybe even empowered.
Hope it helps.
Until our next deep dive, keep those important questions in mind.